for that introduction, and thank you to Fiki and Vaipo to have me over for this chat. And I really do appreciate the platform that I've been given, and I hope that whatever I speak today enlightens the audience a little bit about the landscape on arbitration in India on IP disputes. I'm sure, to begin, if I were to begin with, what truly are the trademark disputes. As in every other jurisdiction in India, there are various incorporeal rights such as trademark, copyright, patents, which are governed by statute, which are specifically created for them. Usually, the IP disputes that arise are in relation to different categories of IP rights. And these could be patents, these could be trademark rights, these could be copyrights, geographical indicators, designs, etc. One of the questions which has always been before the courts in India is that, is arbitration an effective alternate dispute resolution mechanism when it concerns IP rights? And in that, an evergreen question, if I may say so, relates to the arbitrability of IP disputes. But before I come to the question of what is the meaning of the term arbitrability and how this arbitrability has been decided by the courts in IP disputes and how would the court take it forward, let me, in the first instance, bring forth what an arbitration would entail. Now, I'm sure, through the day, maybe you've already heard a bit about arbitration, or if not, then you already have a bit of an idea of what arbitration entails. But in short, arbitration actually refers to contractual method of resolving dispute. That, to me, is the short and sweet definition, as I may put it, of arbitration. By the contract, the parties actually agree to entrust the differences between them to the decision of an arbitrator or a panel of arbitrators to the exclusion of the courts, and they bind themselves to accept that decision. Now, these, as I have put forth, are the main elements, so to speak, of arbitration. One, it is a consensual means to resolve a dispute between two consenting parties. Two, it's a non-government decision maker selected by and for the parties. And three, and the most important, if I may put it this way, that most important attribute, that it is final and a binding decision. What are the advantages and disadvantages of arbitration? If I may very quickly put it forth, the advantages of arbitration are that it is simple and informal, it is efficient and flexible, confidential, it is expeditious, and there is an ability to opt for tribunals who are more adept at specialized subjects such as IP. And I must say that the two most important advantages, as I see it, for people who actually enter into any IP dispute, is one, that there is an ability to opt for a tribunal which is best adapted and best suited to your dispute. And this is not just for IP disputes. This is disputes across spectrum. Take as an example an engineering dispute. Would I rather have an engineer sitting on the panel? My own sense has always been yes. You must have a technical person there who understands the technicalities. I'm not going to say that you don't need a lawyer or a judge or a person who at least understands law on the panel. You do, because there are issues of law being discussed. And someone needs to be able to appreciate it just as a technical person would appreciate the technical questions. So also a legal person is better suited to understand the legal questions and the nuances which are put forth. But the ability of a person to opt for a tribunal which is suited is one of the hallmarks of arbitration. And two, the other advantage, which is extremely important, is that it is confidential. And we all understand, when we are in court fighting an IP dispute, or any dispute for that matter, it is for everyone to see. It's an open proceeding. You don't have an ability of seeking an in-camera proceeding, because that is not going to happen in a commercial dispute by far. So that's the other hallmark, if I may put it that way, of arbitration, because of which people do prefer arbitration, apart from the fact that it brings finality. There is a very limited amount of challenge which is available. So there is, in that sense, certainty, and the fact that, it moves at a far greater brisk pace than what you may have in the courts. Now, what are the disadvantages of arbitration? That is also something that we must understand. I'm not going to say that it is inexpensive. It is expensive when you consider it as against a court proceeding. But again, it's a very relative term, because in a court proceeding, if the matter is going to go on for the length that it goes on for, then certainly, there is much to be said about the sort of expense that one ends up expending by the time they actually see the end of the litigation. So when I talk about expensive, it is in that sense a very relative term. It could be expensive for some, and it could be, relatively inexpensive for some, given the situation that one finds him or her into. Arbitrator neutrality has been a concern forever, and if you pick up any book on arbitration, this is something that you will find is an issue which is discussed quite often. And the third, which, as I said, is an advantage to someone, could be a disadvantage, which is that the grounds for challenge are extremely limited. Now, you may argue to say that, but because the grounds for challenge are very limited, then I'm stuck with an arbitral tribunal decision. And it could be that, the arbitral tribunal decision is not in your favor, and very much a possibility that they have gone wrong in law. And even if the tribunal has actually gone wrong in law, there is very, very limited ground for you to actually challenge it before the court in a 34 proceeding. India now, as you know, as we move along in the international arena, and we are seen as international players, the courts have taken a very pro-arbitration approach, and in a 34, more and more you find that the courts are very, very cagey about giving any sort of relief. So that in certain instances do become a sort of a limiting ground for many people. Now, let me come to the burning question, and as I said, it's an evergreen question in arbitration, and that of arbitrability of intellectual property disputes in India. However, even before we can explore the advantages and disadvantages or rather, we can explore what arbitrability really means, we need to examine the issue of arbitrability from a perspective that it is the basic essence of law on arbitration, and it relates to the very jurisdiction of the arbitral tribunal to deal with a particular issue. Arbitrability has multiple meanings. However, for the purpose of our discussion today, I'm going to deal with only one facet of this term, namely whether the disputes having regard to their nature could be resolved by the private forum of the choice of parties, or whether they would exclusively fall within the domain of the courts, which is a public forum. And in this context, I would be copiously referring to the decision of the Supreme Court, which was rendered in case of now much celebrated decision of Vidya Drolia versus Durga Trading Corporation. It was rendered in 2021. And there is a recent decision of the Delhi High Court. I was just going through it. This has just been delivered in 2023. Decided on 10th of January 2023. Now, to understand what is arbitrable and what is not, it is important to first turn to the distinction between adjudication of actions in rem and those that are in personam. A judgment qua action in rem, as the Supreme Court has postulated, determines the status of a person or thing quite distinct from the particular interest in it of a party to the litigation. Such a judgment is conclusive evidence for and against all persons, which means it is against the entirety of the world, whether those parties across were a party to the litigation or not. Even if it means that those parties were neither privy to this litigation and the fact that all of them were complete strangers, it has an effect of binding all persons claiming an interest in the property, which is inconsistent with the judgment, even though it was pronounced in their absence. In an absolute contrast, action in personam merely determines the rights of the litigants inter se to the dispute. So it is basically inter partes. Again, confusingly enough, use of the expression right in rem and right in personam may not be entirely correct for determining non-arbitrability, because on many occasions, a right in rem ultimately results in an enforceable right in personam. I will refer to the famous authors Mustill and Boyd, who in their classic book on arbitration, on more so on commercial arbitration, refer to subordinate rights in personam that are derived from rights in rem, meaning thereby they flow out of the rights in rem, and these can be ruled upon by arbitrators. Let me give an example and let me make it a little bit more simple. Let's say that there is a claim of infringement of copyright against a particular person. Question is, would it be correct to say that such a dispute is arbitrable? My answer would be yes, though in some manner the arbitrator would actually examine the right to copyright, which is an action in rem of the person concerned. However, in a case where the claim to copyright in relation to, let's say, a sound recording itself is denied vis-a-vis a person, and therefore it is denied that the concerned person had any right to collect any license fee or royalty in respect thereof, there is a decision of the Bombay High Court which has held that this being a dispute in rem could not have been made a subject matter of arbitration. Now, it's very simple to understand really that if the very right of the person is being denied, it is being said that he or she does not own the copyright, then clearly it is a question which borders on action in rem, because it is against the world, because that copyright is not, it does not vest, let's say, in me, and if it does not vest in me, much less can it be said that it's me against anyone in particular. It's me against the world as such. And therefore, to my mind, the Bombay High Court was quite right to say that it is a dispute in rem and could only have been taken care of by the public fora, namely the courts. Now, in a similar vein, while the rights under a patent license may be arbitrated, but the validity of the underlying patent may not be arbitrable. Now, it's quite similar to what I have stated in respect of the copyright dispute. It is important to understand that grant and issue of a patent or a registration of a trademark are matters which are exclusive and which fall within the sovereign function, and thus these confer monopoly rights and are therefore necessarily non-arbitrable. But as I said, anything which flows out of these will certainly be arbitrable. Now, I can replicate examples even away from IP issues for a better understanding of all of you of what is arbitrable and what is not. So let us consider insolvency and intra-company disputes. We all understand that there is a special forum. There is a special statute insofar as insolvency is concerned. We have IBC now. Prior to that, all of it would have gone under the Companies Act, and therefore insolvency disputes cannot go into a private forum, namely arbitration. Similarly, intra-company disputes, we are all aware that there are issues which arise under the Companies Act and can be resolved only under the Companies Act. Earlier, they would have gone to the Companies Tribunal. Now they would all go into NCLT. So these are two, prime examples of disputes which are required to be addressed, as I would put it, by a centralized forum. Again, criminal cases, they are not to be arbitrated as they relate to not just the victim per se, but they also relate to the sovereign functions of the state. We must also understand that these kind of cases are intrinsically offenses against the state and not just against the victim. Then again, matrimonial disputes relating to dissolution of marriage and let's say restitution of conjugal rights. Can you say that these are arbitrable? The answer would be no. But important for us to remember if the husband and wife have entered into an agreement for distribution of the properties on dissolution of marriage, which contains an agreement to arbitrate, that would certainly be arbitrable, because that has nothing to do with a right in rem. Because let's say a dissolution of marriage is against the world to say that, here one, obviously it is under law, and then the other is to say that here you have a parting of ways between people, and everyone knows. But when they part, they've already entered into an agreement, and that agreement is that if ever we were to part, here is an agreement between you and I, and in that agreement we have distribution of properties on such a dissolution of our marriage, then certainly that can be taken into arbitration. Thus, the Supreme Court has made a succinct distinction between actions which determine the rights and interest of the parties themselves in the subject matter of the case, and actions in rem, which refer to actions determining the title to the property and the rights of the parties, not merely amongst themselves, but also against all persons at any time who claim an interest in that property. While rights in personam are amenable to arbitration, disputes in rem are unsuitable to be adjudicated by the private tribunals. And yet another species, namely subordinate rights in personam, that arise from the rights in rem are considered to be arbitrable. Having said all of that, it is equally important to understand that arbitrability of disputes forming the subject matter of suit and the arbitrability of a claim are two different things. A claim may not be arbitrable because of the limited scope of the arbitration agreement between the parties. Now, we must understand that many a times when we are crafting the agreement to arbitrate, we would normally put fetters on how much can be arbitrated under the contract. There are certain parts of the contract which we would say are not going to be arbitrable in that sense. So your claim therefore could be limited on account of the limited scope of the arbitration agreement between you and your counterparty. But it's quite distinct from saying that the subject matter of the agreement itself is non-arbitrable. Now, if your subject matter of the agreement is something which is non-arbitrable, then that's a completely different issue. And that's the reason I said that we are talking of two different things altogether. So, suffices for all of us to understand that subject matter of the suit is normally non-arbitrable when it is not amenable to resolution by arbitration, and claim per se could be limited in its scope on account of your own agreement that you have entered into with your counterparty. One of the other very important questions which has troubled, if I may put it this way, the courts in India is who decides on non-arbitrability, because we all have experienced this quite often, that Indian courts, at least in the past, have jumped quite too often, even in a matter which was otherwise to be left to the competence principle of arbitration, and to the therefore to the competence of the tribunal. Therefore, usually you will find a Section 11 application which is for the purposes of appointment of arbitrator, or a Section 8 application which is to refer parties to an application to arbitration. In either of the two, one of the questions which has troubled the court is that does the court decide this question when any one of these applications are before them. Now, the Supreme Court in Vidyadhrolya has actually, to my mind, put an end to this issue. In Vidyadhrolya, the Supreme Court actually decided that usually subject matter arbitrability cannot be decided at the stage of Section 8 or Section 11 of the Act unless it is a clear case of deadwood. According to the court, the scope of the court is in either of the two provisions is to examine prima facie validity of the arbitration agreement, including on rare occasions whether the subject matter of the dispute is arbitrable. Now, to me, it's the last portion which is a little troublesome, because in the Indian context, given the number of courts that we actually come up before, and this I'm not just talking about sitting in Mumbai, I'm not just going to talk about, jurisdictions like Mumbai or Delhi or Bangalore or Chennai for that matter. But we are looking at India as a whole. And when you look at India as a whole, you know that you come up before different courts, and it is not necessarily just before high courts, because in different jurisdictions, you may come up even before the civil courts. And given that number, sheer number, before sheer number of courts that I'm talking about, before who the application under the aforesaid provisions can likely come up, it is a daunting task, to say the least, for you to try and convince the court that, look, the Supreme Court has actually said that you should look at arbitrability only in the rarest of rare occasions and not otherwise. So it's a very relative thing. It's a very subjective thing, and it will obviously depend upon the court concerned on how it will look at this in its entirety. I would like to very quickly sum up, because I know that I'm running against the watch here. So just to conclude, the conundrum, if I may put it this way, persists as to whether IPR disputes are arbitrable or not, because this is an issue which will come up before various courts in the country, whether we like it or not, and the courts will take a stand one way or the other. Though from the analysis of the case laws that I have made, including the recent decision of the Delhi High Court in Liberty issues, it is obvious that there can be no blanket bar on the arbitrability of disputes relating to IPR arising out of the agreement entered into by the parties, and it will depend on the facts of each case. If a dispute is arising out of the terms of the contract between the parties, even though such disputes pertain to copyright or trademark infringement, it still could be decided by arbitration. Though most of IPR disputes arising out of contract will be amenable to arbitration, but not every dispute. Disputes as to the validity stroke ownership of IPR are still not arbitrable. Imperative for foreign investment and globalization that Indian courts do adopt a wider approach to enhance arbitrability of IPR disputes. The ICC final report on intellectual property disputes and arbitration even states that there are no substantive differences in arbitration arising out of either intellectual property disputes or under any other area of dispute for that matter. So, hopefully, as what we have seen, the approach of various courts in India, which is to my mind pro-arbitration, arbitration friendly, and where the courts do not want to enter into arenas where clearly the dispute is arbitrable, I am quite hopeful that as time moves on, arbitrability of IP disputes will only become that much more important in the Indian jurisprudence. Thank you so much. With that, I come to an end of my presentation. Thank you.
Thank you, Mr. Thakur. Thank you so much. I think you set the basis of for discussions today. As the next speaker for this session, Ms. Jane Clare, is a little caught up somewhere. She'll be joining us later. We will move on to the next session, which is on mediation and arbitration for IP and commercial disputes. And I'd like to first invite Ms. Geeta Luthra, who's a senior advocate in the Supreme Court of India, and she's the vice president of ICA and a member of the ICC India Chapter Core Committee. And she's also been practicing law since 1980 in the Supreme Court of India and various high courts of India, and has served as a sole arbitrator in many cases, domestic and international arbitration. Geeta ji, may I invite you to please come in? Thank you.
Yes, it of course makes me feel very old when you say I've been practicing so many years, but thank you nevertheless. I think Mr. Thakur has actually set the tone for the subject. And according to me, the question, of course, is to be or not to be. The question is IPR to be included or not to be included? And this is one of the interesting aspects of arbitration, which is still an open chapter and therefore very, very interesting. Not very long ago, the Supreme Court in Vikas Sales Corporation, I think it was a 1996 Supreme Court judgment, said that these cases which are pertaining to intellectual properties, whether trademark, copyright, patent, they should not be arbitrable. Now, along comes our 1996 Arbitration and Conciliation Act, 1996, and Section 8 is very categorical. It says very categorically, there are disputes which are non-arbitrable. Now, among the disputes which are non-arbitrable are judgments in rem. Now, what is a judgment in rem? A judgment in rem is a judgment which is good against the whole world. Now, what does it mean? So if A and B have a dispute and it goes to a court of law, then it crystallizes. If you go to a court of law, you get a judgment or a decree, it crystallizes the rights of the parties vis-a-vis each other. Now, judgments in rem and in personam are dealt with in India under the Indian Evidence Act, which is Section 41, 42, 43 of the Indian Evidence Act. Judgments in rem are, for example, admiralty cases. Judgments in rem are cases which pertain to matrimonial disputes. It relates to the status of a person. These are some of the aspects. Probate. Probate is a judgment in rem. Therefore, it's often said, with regard to a will, you can't be having an agreement. People have an agreement, agree that the will was void, and then go into an agreement or an arbitration or a settlement. Per se, however, because these are judgments which bind and status which binds all of humanity and is good against the whole world, is good against the public. That's why they're called judgments in rem. Now, when IPR was and the law on arbitration was developing, now 1996, the act was then interpreted in terms of, and Booz Allen, I think, came just before the enactment, and the enactment almost echoed Booz Allen. But now the fact is that it's one of the issues that came up a little while ago in the Supreme Court was take a statutory provision like the Delhi Rent Control Act, take the Transfer of Property Act. Are disputes with regard to property judgments in rem or judgments in persona? There were judgments all over the country, Bombay, Delhi, other courts. Ultimately, it was decided that these are non-arbitrable. Matter went to a larger bench of the Supreme Court because they said it can't be that all disputes with regard to property are non-arbitrable or transfer of property. The court then has made a distinction saying there will be those where there is a protection under a statutory rent enactment. Those in which there is no protection, they are arbitrable. Now, insofar as intellectual property is concerned, lest I stray from the subject, question was, is trademark, is copyright, are patents subject matter of arbitration or not? So the way Booz Allen laid down the law, which was earlier laid down in Vikas Sales Corporation, both same year, I think, of decision, actually, insofar as that was concerned, Vikas Sales, it was 1996. Booz Allen perhaps was much later, but it interpreted the 1996 enactment, perhaps in 2011. And that enactment was once again looked at in Himangi, and then the Supreme Court, Justice Nariman's bench, referred it to a larger bench, and the whole issue of arbitrability was rehashed, trying to say that disputes, as far as possible, should be arbitrable, only cases of fraud to be excluded. Then fraud also came in two categories: civil fraud or criminal fraud. Criminal fraud to be excluded, civil fraud not to be excluded. But coming back to our subject, the fact is that after this came Vidyadhrolya. Vidyadhrolya basically said that if it affects third parties, then and has implications on the public, so an in rem interpretation, then it would be non-arbitrable, because you can't have two people choose a forum to have a dispute resolved, which will affect the whole world. So therefore, it should be non-arbitrable. But if it does not affect third parties, the question arose, and that is the gray area. Where it affects the public at large, it will be non-arbitrable. Now, what are the disputes which so slowly arbitration came to entrench and hold the field in various areas of law, where it said these are arbitrable, but what kind of IPR disputes are arbitrable? And in Vidyadhrolya, the Supreme Court says those which affect third parties. In Hero Electric, which is a Delhi High Court judgment, and very recent judgment, quite erudite, it says that a contractual relation between two parties normally cannot necessarily be a right in personam, because it may affect the rights of general members of the public. So you can't be just saying, I resolve this dispute, even though it entrenches on various other people and various other members of the public who are not parties to the dispute. So that is the distinction between judgments in personam and judgments in rem. So now the new interpretation came that in cases which could otherwise be assumed to be cases in rem, that is intellectual property rights cases, question is that if it affects only, if it affects only the rights in personam, then it would be a I'm sorry. Can you hear me? Am I okay? Yeah. So if it affects rights which impinge on other people, then it would not be open to arbitration. Now, slowly, the movement has been, whether we look at the law in the United Kingdom and the enactment with regard to the UK patents, if we see that slowly the courts are now, or the enactments are now going towards a more expansive interpretation, so that arbitration is a way forward as long as it is not impinging on rights of the public, as long as it is not interfering and is not contrary to the New York Convention. It is basically saying that trademark copyrights are clearly arbitrable. Patents, there may be an issue, because patents, there is an effect on not only the inter se parties, but several other parties. So one of the arguments that's being made is that even when a dispute is between two parties, it should be restricted to determining only the dispute qua the parties. Insofar as Switzerland is concerned, it is saying that subject to the New York Convention, recognition, enforcement of foreign arbitrable awards is there. Hong Kong, again, the arbitration ordinance governs arbitrability of intellectual property disputes. We've now recently in India had the Commercial Courts Act. One of the issues is pre-litigation mediation. Now, one of our judgments, a recent judgment by a bench of Justice Bakru, has said that this can only be possible, it cannot be mandatory, and it can only be possible in those cases where there is no urgent relief prayed for. And another bench of Justice Pratibha Singh, who, while she was a lawyer, was one of the most well-known lawyers on intellectual property in bold technology. She said, and I quote her, "As per the experience seen in intellectual property cases, the relief of interim injunction, including at the ex parte stage and ad interim stage, is extremely important. Such matters do not merely involve the rights, interest of the plaintiff and defendants, which are the contesting parties before the court, but also involve the interest of the customers, consumers of the product and services in question." So, while we have Section 12A of the Commercial Courts Act in place, which makes it mandatory, and therefore all intellectual property cases which even go to court now become subject to mediation. But the question is, should all cases go to mediation as a first step? The courts have now said no, because there will be urgent relief which is required, which cannot go first to mediation. You get relief from the court and then make an attempt at mediation. What's good about arbitration? One, I'm always an advocate for institutionalized arbitration. Second, arbitration may be slightly expensive, but it does resolve disputes. It solves the problem, and therefore there is a way of going forward. How many cases would you see where, when you are litigating bitterly in court, you think of forging the business together? In intellectual property cases or other arbitration cases where parties don't have their tempers risen so high, it is very possible that they may actually see that they can carry on a business together, or operate in different fields, or settle their differences. So all said and done, to my mind, the world is moving towards making intellectual property disputes arbitrable, as long as it is not impinging in areas where it would be strictly and strongly against the public interest and affecting members of the public. Having said that, may I say thank you for listening to me so patiently, and I hope I've covered a major part of what I wanted to say or bring forth. India is plodding along and is moving in the direction of making more and more disputes in IPR arbitrable. And one of the aspects which is being considered important is that we can involve experts, although we would not rule out counsel. Thank you so much.
Thank you, Geeta ji. I think that was a very interesting overview of arbitration in India, developments, expectations, and thank you so much. We'll obviously have some Q&A kind of interaction with you, I'm sure, going forward. And meanwhile, I'm very happy to announce that Ms. Jane Clare has just joined us sometime back. Like I said, she's commercial mediator at the London-based Independent Mediators. She's a leading international mediator and also with extensive experience in international dispute resolution. Jane, may I invite you in for your comments? Thank you.
Thank you, and it's lovely to join you all again. It's been I've always enjoyed having an involvement in these international discussions around ADR in general. I've been asked to talk to you about IP disputes in the context of mediation. And I think the first thing I wanted to ask myself when I was preparing this talk is, there still are, in my mind, too few IP disputes going to mediation, and I wonder why. And it was interesting listening to Geeta about some of the issues in relation to the need for the courts in getting you instant relief. And of course, that's always an option for our parties to rush to court and get injunctions when they need them. And of course, in the IP world, that's often required. So we know that mediation is not an alternative, but a complement to those kind of redresses. But it seems to me that also the other reason why perhaps mediation isn't picked up in quite the volume that other sector disputes have been in IP is because arbitration is also very, very effective for resolving IP disputes. We know that it's confidential, often very important for IP disputes. We know it can often be quicker than the court system. And we know that you can get specialist arbitrators, particularly if you go down the WIPO route and you pick up a WIPO arbitrator and you've got specialist IP rules that you can use that are very, very helpful in IP disputes. So again, that might be a reason why parties and their lawyers don't naturally also think of mediation. But as Geeta mentioned, and I think it's very important that we as advisors are always having a mind to, does mediation also play a role, and can we use mediation as a complement to the arbitration or the court systems wherever we operate? It seems to me that IP lawyers sometimes believe that IP disputes are too complicated to be resolved by mediators. And I remember being in law firms where I was not the IP lawyer, and my IP friends were telling me that, oh yes, mediation is a great idea, but not for IP because it's way too complex. Now we know that's not true. We now know we've got mediators who are just as qualified in the IP world as our arbitrator colleagues, and therefore really IP mediation can lend a hand towards resolving disputes quickly. And it seems to me that the interdependence across the boundaries for business, as it expands and as an innovation through the IP systems help us develop things internationally, the IP rights need protection. And sometimes the courts and even the arbitration system is too clunky. Different jurisdictions have different ways of dealing with IP. We find that actually the systems are out of date to be able to react quickly to such an innovative area of the law. And it can be too expensive, and often it takes too long to resolve disputes that involve IP by using arbitration or the courts. So let's consider why mediation could be different. Of course, it can be very, very quick. You can get a mediation up and running within days. You can put together the succinct one bundle that a mediator can read. You can exchange a very short position paper, and you can be in front of each other by Zoom or in person very, very quickly. Now, of course, that comes with risks. You may not necessarily have got all your evidence together. You may not necessarily have got your experts' reports together, but speed might be a very important factor for your client. A quick settlement might mean the client can get on with his innovations he can get on with doing the job he does, which isn't litigation. We also know that mediation is very creative. It's not bound by precedent, it's not bound by previous law, it's not bound by statute. Solutions regarding sharing of the ownership, licensing, excluding certain uses to avoid competition can all be on the table. When you think about algorithms, when you think about chemical formulae, which are often wrapped up in IP protections, these can become outdated in the very time it takes to bring something to court. You want fast solutions, and sometimes an injunction is the right course, sometimes it's getting around the table and thinking commercially and creatively that will allow you to find a solution to a dispute. I can remember a dispute that I was involved in as an advocate only a few years ago now, which involved missile technology. The software was being sold, and there was a dispute arising in relation to what was bought and how much was bought. If we'd gone to court, it was all well and good in terms of the actual debt dispute, but the IP software had moved on, and the seller wasn't prepared to sell more to the buyer whilst there was a dispute. So although the courts were available, mediation was a much better resort for those parties to be able to resolve the issue in relation to the debt and allow the IP and the new versions of the IP, the new versions of the software to be sold to assist in what was inevitably a defense contract. So how do we harness those commercial use advantages that clients are calling out for? Of course, we need to set out the rights clearly, and that's what contracts do. But contracts are not flexible. They won't protect you necessarily if before too long, within months or possibly years of a long-term contract, what's happening on the ground for your clients is not reflected in the contract itself. And one of the recent trends that we've been seeing is deal mediation. So what is that? Well, deal mediation recognizes the fluidity of the IP world and the hopes of the parties in anticipating and dealing with change during the life of the contract. I wrote as long ago as 9 years ago in the Intellectual Property magazine that we were seeing an evolution of mediation, the IP mediation moving up the food chain, dealing with pre-dispute issues where parties in terms of dispute management were anticipating with their clients what might happen along the way and how would we deal with it. Appointing a mediator at the outset of the contract when all was harmonious and parties were friends, so that when there were bumps in the road or issues arising, you could freeze the milestones, bring in a mediator for a 30-day period to try to bash heads and sort things out before the issue became a dispute. We see that the evolution of IP management in contracts and the dispute management in terms of court process are not becoming aligned. IP mediation is often much more about interests and needs than the powers and the rights that courts deal with. The facts and the law and the position that a party has taken, that's the domain of us lawyers. But why did that dispute arise? What do the parties need now? And what can the contract do is often misaligned. And that might be what the parties, what the clients really want to deal with. The flexibility to be able to renegotiate your rights is essential. It makes the law and the ability for lawyers to only look at what the contract says a bit clunky, a bit binary, inadequate perhaps. And yet mediation can well be the answer of giving the parties back control of finding a solution to what's gone wrong and allowing them to create value for both of them whilst adjusting the contract. I remember a long time ago, Michael Leeds, who was the IP General Counsel at British American Tobacco, told a wonderful story of how he had just joined the company and he'd realized that the company had spent millions on an IP dispute with a company in India. And he couldn't work out why they had spent so long and lost. And he wanted to speak to the General Counsel who'd won the IP. When he'd gone, he contacted them, and the GP, the General Counsel in India, invited him over to India for dinner. Michael flew to India. He had supper overnight with that General Counsel, and at supper, the General Counsel handed back the very patent that they'd been fighting over for 4 or 5 years at great expense to both parties. When Michael, astonished, wanted to know why, he said, "This was never about the patent. We don't need it anymore. We don't want it. You could have had it. But the way you dealt with my grandfather was so insulting. that I was not prepared to put up with it. But here it is, have it back. Michael said it was the moment when the scales fell off his eyes and he realized that if we as lawyers don't sit back before we issue arbitration and litigation and ask the client, why might this have happened? What had we possibly done in the relationship of the agreement that had caused a dispute? We might have avoided a huge amount of costs. So we need to know the why and the how and not just the what of disputes. We know only too well that relationships in the technology world, in the IP world, are vital. And often clients in these sectors are very limited. They move in very small circles. And there's very few in the market that can provide the specialist needs that our clients need. Mediation is going to help preserve those relationships and maybe reconfigure the programs, maybe reconfigure the long-term agreements to better reflect the reality on the world, on the ground rather, and for a very little deficit to the parties. It could create value for both of them. And a good mediator who's got the knowledge of IP as a neutral helps those parties negotiate through a solution. And whilst it might not be a win-win, as we talk about in mediation, is infinitely better than the court system or a collapse of a commercial relationship. In my experience over 35 years as an IP lawyer, I recognize that large corporations often have vast IP rights. They've got trademarks and patent portfolios, and they're now looking at mediation as a way to be able to create more creative outcomes and create value out of their IP portfolios. If you listen to the comments made by the likes of Asco Nobel and Nestle, who have huge IP rights, they all talk of ADR and mediation as an opportunity to turn a dispute from a business threat to a business opportunity. So lawyers advising need to hear their masters' voices and adapt their advice accordingly. Because in a world where we recognize the operation of IP rights will differ from country to country, and where some countries indeed will struggle to recognize IP at all as a right, we have got to be creative and look at ways to look at these intangible assets in a very different way. You've only got to look at the iCloud to see that ideas and know-how now is being shared in a very profitable manner for both buyers and sellers. Proprietary information is much more difficult nowadays to ring-fence. So we as lawyers have to find interest-based solutions, innovation in the way we do our law to make sure that the future allows for these kind of disputes to be managed more effectively and prevent other expensive disputes in the future. Thank you.
Thank you so much, Jane. I think that was another very interesting and informative presentation, especially from the IP perspective. We now move on to, I'll invite the next speaker, it's Isha Singh. Briefly to introduce her, she's a legal case manager, IP disputes section at WIPO Center. She's a dual qualified attorney with progressive legal training, with expertise in IP, healthcare, food and drugs regulation, e-com, and commercial contracting. Isha, please come in. Thank you.
Thank you. Thank you very much, Dipankar. And at the very outset, I would once again like to thank Vicky and ICA for facilitating and organizing this webinar, as well as our distinguished speakers for their time and expertise. And thank you all for tuning in. So I am a legal case manager at the WIPO Arbitration and Mediation Center. I will be providing you a short update on the center, its rules, some general trends that we've seen in the area of IP and commercial disputes, and just another housekeeping update. Please feel free, now this is a remote seminar, so please feel free to shoot out questions our way using the comment section if you're live streaming on YouTube, or using the chat function on Zoom. Now moving on, the WIPO Arbitration and Mediation Center, we've been around since October 1994 with offices in Geneva and Singapore. I am also quickly going to share my slides here with you. And we are part of the IP innovations ecosystem here at WIPO. The role of the center is essentially assisting parties in resolving commercial disputes outside the courts through different forms of alternative dispute resolution mechanisms, or ADR. And the center offers international neutrality as a forum, as well as strong specialization in IP and technology disputes, which is reflected especially in the list of arbitrators, mediators, and experts that we maintain, and from which we appoint candidates in some of these cases under the WIPO rules. The WIPO Center offers the whole range of ADR services, including mediation, 2 forms of arbitration, standard and expedited, expert determination, and dispute resolution boards. The center provides procedural assistance from submitting disputes to ADR to the selection and appointment of neutrals. And I think it's noteworthy to mention here, because we've received a lot of good feedback from SMEs and MSMEs. So through the WIPO Good Offices service, the center provides procedural guidance to parties who are contemplating submitting a dispute to WIPO ADR. And we've seen that this complementary service is especially beneficial to SMEs. And we've seen a lot of Good Offices requests, which have later converted into mediations, and they've been able to resolve their disputes successfully in a cost-effective way. I would also like to mention that the center offers a discount in administrative fees if either of the parties to the dispute is an SME. As part of its case administration services, the center also provides a series of online case administering tools, which have been very, very useful and cost-effective for parties, especially in these past 2 years. And in administration of such procedures, the center draws on its list of neutrals comprising highly specialized arbitrators and mediators with expertise covering almost the entire legal and technical spectrum of intellectual property, and includes a specific sublist specialized in domain names, life sciences, standard, essential patents, among other areas. Now on this slide, you will see that largest portion of all our cases relate to patents, followed by copyright, trademarks, IT disputes, and commercial disputes. Now I would like to highlight that in our IP arbitration case experience, arbitrality has barely been an issue, with most cases arising out of contractual or licensing arrangements between the parties, which relate to contractual claims between the parties. So, and as for the source of our cases, traditionally, most of the cases are based on contract clauses in agreements between the parties, but we've been seeing an increasing number of cases that are being referred to WIPO mediation or arbitration after the dispute has arisen, for example, infringement disputes. And most of our cases have traditionally and are still international, with parties based in different jurisdictions or rights protected in different jurisdictions. We offer services in a number of languages. And as Heike mentioned, the settlement rates, the average settlement rates in WIPO cases have been quite good, of more than 70% in WIPO mediation cases and almost 33% in WIPO arbitration, which is, I think 1 in 3 cases have settled before the arbitral award is even rendered. Of course, the big trend in the last 2 years was the move to an online conduct of all of our proceedings. But even now, we see about 95% of all of our proceedings are still being conducted entirely online. There has been a substantial growth in our caseload with 45% in 2021, and we are expecting even bigger growth this year. The center has developed WIPO mediation, arbitration, expedited arbitration, and expert determination rules for use in various dispute resolution procedures. More importantly, I would like to highlight that these rules are applicable in any legal system and any procedures in the world, provided there is agreement among the parties. And any person or entity, regardless of its national affiliation, may refer the dispute or for resolution under either of these procedures administered by the center. And these rules have built-in provisions specific to IP and commercial cases, such as party-tailored scope of dispute and schedule in consultation with the mediator and arbitrator, confidentiality, interim relief, and technical evidence. Now I'm going to go on to the next slide. And going back to what even Jane said about the use of mediation as more of a facilitative ADR mechanism to help parties in concluding agreements, and I think this case is a good example of that. And we've had many others where parties have, there has been a dispute and parties have gone ahead and resolved that dispute, but also have gone and signed many more agreements in the future, which are completely unrelated to the dispute, but somehow related to the subject matter of the dispute. Well, in this case, the parties are a European telecom company and an American telecom company. The dispute mainly pertains to a patent licensing agreement in relation to 3 patents that were registered in Europe, US, and Asia. And the dispute resolution clause in the agreement provided for WIPO arbitration, WIPO mediation, followed by WIPO arbitration. Parties were unable to reach an agreement on the mediator, which is why the center provided them with a list of specialized experts, of which one such mediator was appointed. A single in-person session with the mediator resulted in the successful resolution of the dispute, and parties ended up signing a settlement agreement within a few months from the commencement of the mediation. The second case example relates to a recent arbitration case involving 2 European pharmaceutical companies arising out of a joint development and option to license agreement for the development of a cancer treatment. This dispute as well, it started with various smaller disputes relating to assignment of rights concerning a few jointly developed patents, but the main dispute arose when one of the parties allegedly sub-licensed one such jointly developed product to a third party without the consent of its co-developer. It was an interesting dispute. Here, the parties decided to enter a submission agreement to refer the matter to WIPO arbitration, and they jointly agreed to limit the scope of issues that would be subject to the tribunal's determination to 2 main areas, which consisted of A, the financial elements such as sub-license revenues and royalty rates, and second being co-ownership status of the 3 specific jointly developed patents. Now, during the arbitration proceedings, the 3-member tribunal also ruled on several other procedural aspects, such as admissibility of expert witness reports and scope of discovery, while rendering a final award on the patent ownership status of the patent in dispute, as well as the royalties. Now, this brings me to the very end of my short presentation, and I will hand it back to Dipankar. Thank you very much for having me. This last page of the presentation includes some links to our websites, to the rules, to the procedures. So please feel free to take a look at them.
Thank you, Isha. Thank you for that update on what WIPO Center does in this regard. Well, ladies and gentlemen, we now move on to the Q&A section. I would request the participants, like Isha suggested, if you have any questions, etc., to please use the chat box and send them to us, and we will make an effort to take them up through our experts. And to moderate this Q&A session, I'll invite Isha of WIPO Center to kindly take this interaction forward. Isha, would you like to come in?
Absolutely. Thank you, Dipankar. So we have received quite a few questions, and the first question is from Shrishti Chetra. She asks about the role of arbitration to settle IPR related disputes, and what are the disadvantages, what are the advantages, and I think now she hasn't addressed this question to anyone, but I think Naresh ji can take this up and offer some insights from his experience on this.
Yeah, thank you so much, Isha. I think I did touch upon the advantages and disadvantages of arbitration while I was actually presenting. So, but just to revisit that, to my mind, a lot of advantages that arbitration does offer. Obviously, mediation is something that I also believe that one should try, because that truly preserves party relationships. But if you cannot, and if you cannot arrive at any sort of a solution through mediation, then arbitration then becomes your next best option, as I see it. You're away from the court. You do not have the various court processes don't bind you. You are not bound by at least the in India, the Civil Procedure Code. You're not bound by the Evidence Act. You can choose, as I mentioned, your arbitrator. Your arbitrator could, and you obviously can choose neutral arbitrators, which one must, and ought to choose. These arbitrators, you could have specialist arbitrators. You do not need necessarily to have either lawyers or judges. You can have technocrats for all you care. Though, again, as I had said when I was presenting, I do believe that it's important that you also have someone who does understand the legal nuances, because ultimately arbitration, despite the fact that it's a private forum, it's ultimately a judicial process through which a award is rendered, and which award will ultimately be challenged under the provisions of the Act. So it's best that you have a judicial mind at it as well. So it allows you a private forum. Costs, again, like I said, I mean, it is a very relative thing. Some believe that it is expensive, but I personally do believe that in the end, it does give you, it does bring the cost down considerably if run in a very efficient manner. And if it is run through an institution, then obviously you see the cost effectiveness far more than what you would do if it was a ad hoc arbitration. So that's another advantage. And like I mentioned earlier, confidentiality, which is something very important to all IP disputes for that matter. That's something which arbitration offers. And in the end, I believe the certainty that you get with arbitration once an award is passed, and the limited aspect of challenge, that is something which to me is a huge buy-in for people to actually arbitrate on IP disputes rather than taking them to court. So those are my views in short.
Thank you, Naresh ji, for offering your insights. This was very helpful and sort of resolves. I hope this resolves Shrishti's query. The next question is mediation compulsory before taking the formal process of litigation as per the WIPO rules? Now, I'm happy to take that question up. As per the WIPO rules, especially the WIPO mediation rules, I think they offer ample flexibility to the parties in terms of deciding whether to and on how they can draft clauses to submit disputes to WIPO mediation. More often than not, mediation is also, it may be court referred. It can also be, we also provide for unilateral requests for mediation, wherein one party files a request for mediation and we reach out to the responding party to see if they are interested. Of course, agreement between the parties is an essential to WIPO mediation. So it isn't compulsory to do anything in mediation as such. You as long as the parties are in agreement, and you can basically customize the process as you like in consultation with the mediator. Now, looking at the comment section on YouTube, what is the basis on which ICA allots arbitration cases to registered arbitrators of ICA? I'm sorry, before I give that away to Amit or Geeta ji, I will let Jane also offer her insights on the previous question regarding mediation. My apologies. Jane, you're on mute.
Thank you.
There
Sorry,
you
thank
go.
you, Avisha. I just wanted to just comment about compulsory mediation. It is interesting, and it's a really fascinating. There's lots and lots of people talking now about how a lot of courts are pushing for compulsory mediation, really to help the backlog of the courts, because particularly after lockdown in many jurisdictions, the courts are not coping. We now have compulsory mediation for claims under 10,000. So for the smaller claims, that's being pushed. And it is believed that our government in the UK will be making that, they will increase the need for mediation. You'll also then get government appointed mediators, so we'll see how that works out. But I think compulsory mediation is more compulsory, forcing you to go into mediation, not, as Isha says, compulsory settlement. So at the end of the day, whilst you may mediate, if you don't settle, that's your own, that is your own decision still. So no one can force anybody to settle. But I think the compulsory use of mediation as part of the dispute system is going to happen in a lot of jurisdictions soon.
Heike, would you like to go next on that question?
Thank you, Isha. Just very briefly, just to add one comment on that question, which I agree is a very interesting question. Just to follow up on what you were saying, Isha, that we have quite a high settlement rate in arbitrations. 1 out of 3 arbitrations settle. And of course, there, had the parties been going through a mediation before that, the arbitration may not have even been necessary. So again, under the WIPO rules, it's not compulsory to first go through a mediation, but we see in practice that it can be very helpful. And even if the case or the dispute does not settle entirely in the mediation, parties may be able to narrow the dispute and only refer the remaining part of it to arbitration. So in our view, it's definitely always worth a try. Thank you.
Isha, if I may, just jump in on this question, because it's interesting what Jane mentioned, and I must say that in India as well, there is a provision within the Commercial Courts Act where the courts will actually send you to compulsory mediation before the courts would accept you to file the suit. So I think, as what Jane mentioned, in many jurisdictions, including in India, you now find that the courts are that much more mediation and mediation friendly. So they want parties to look at solutions outside court, and in India more so, because the dockets on each of with each of the courts is just so heavy that they are not able to, we see backlog after backlog, and maybe mediation could be the way forward.
Thank you, Naresh. Geeta, off to you.
So answering this aspect of the question, obviously there are many now mediation sort of become, apart from the Commercial Courts Act, which even I had spoken of earlier and Naresh has just spoken of. The fact is that to a large extent, I see our courts forcing, virtually persuading people, to the extent of, the persuasion becomes weighty, saying you have to go for mediation. Sometimes parties are still not ready for mediation. Sometimes you have to see when a party is ready. So under the Commercial Courts Act, in view of the judgment I just spoke of, Justice Bakru's bench's judgment, saying sometime pre-litigation mediation before you go into the court, within the filing of the proceedings may not be necessarily the best and most advisable when urgent relief is required, but somewhere along the way, one has to be trying mediation. So I think now this aspect, and I often say that we leave that 20-day gap for saying if parties at some point want to explore mediation, we encourage them. We shouldn't be insistent, but we at least can goad them on to that way.
Thank you very much, Geeta ji. Would you also like to shed light on the previous question, on the next question regarding the process and qualifications of for the appointment of arbitrators in cases at the ICA?
I think Amit is looking at answering that question, but I'll just give my 2-penny bit and then Amit can speak on it. We actually, in view of the fact that sometimes parties have their preference of arbitrators, sometimes we are looking at experts, sometimes we're looking at technical people, and we're trying, among the good people, we are trying to rotate it as much as possible, because you actually have a huge pool. So you see the quantum, you see the panel, you see who are people who are doing very well in arbitration, mediation. Sometimes parties want someone who has a lot of time so that they can do an expeditious hearing. All those aspects are looked at. And the rest Amit will answer, because as I said, I opted out of the arbitration committee for the last couple of years.
Thank you, ma'am. Just to elaborate on that particular, firstly, for qualification, the Act itself, the Arbitration Act of India itself guides that the qualification under Schedule 8, which is there should be for any manager or any advocate, he has to have minimum of 10 years of experience, and then any chartered accountant or another financial expert, they also have to have similar experience of 10 years. And for any bureaucrats or any senior judge, so for them, the qualification has been for again, they've been served in such a position. So itself is deemed to be an honorary position. So that's kind of a let down rule, and we follow the same rules for to empanel any arbitrator. Firstly, in ICA, again, the quality arbitrator been one of the major questions. So we've been very strict in scrutinizing all this. If they have attended some training, certified training programs, have taken expert or been part of some arbitration in some or other way, so then it is more preferred, and particularly and I'm coming from the ICA standpoint of view. We don't I can't tell about other institutions, but ICA being one of the oldest and established in the year 1965. So just to give you a background, ICA started in 1965, and it has done so far around 3,500 plus arbitrations. The success rate is above 90%, which we have closed, and every year we do around a large volume of arbitrations, which claim values are upward of. Last year itself we did around upward of $400 million in terms of, if I speak in that volume, and so again, and we do, if I say domestic arbitration to international arbitration, it is 1:10 ratio. So that's again a very huge number for ICA, and we have around 2,500 empaneled arbitrators as of now. We have 6,500 plus members. So so we have made a democratic committee, which is called Arbitration Committee, and they look after the brief goes to them. The committee itself is derived from FICCI, one of the founding body. Then we have Ministry of Law and Ministry of Commerce, both. So it goes to those committee, and then depending on the case brief. But in the recent judgment of Supreme Court, where in the ONGC matter, party autonomy has been given a more privilege. So parties firstly nominate their arbitrators, and then the presiding arbitrator is being decided by the nominated arbitrators of the parties. So that's again one major aspect.
Thank you, Amit. Thanks, Amit. Heike, from the institutional standpoint, would you also like to pitch in on the final question regarding the process of appointment of an arbitrator in an arbitration?
Thank you, Isha. With pleasure. And I think in a way, under the WIPO rules, of course, typically, as Isha was also mentioning before, the cases are submitted to WIPO arbitration or also mediation are international. So we are looking at a couple of factors before we appoint. And in any case, we normally don't just appoint, but we do this in consultation with the parties. We have a list procedure. So we pre-select from our very large list of arbitrators and mediators that includes some 2,000 experts from around the world. We establish a short list, and for this short list, we look at matters such as expertise concerning the IP or the subject matter at stake. This can be a patent dispute, this can be a trademark dispute, or any other subject matter. We look at the applicable law in international disputes. That's typically relevant. We look at the language or languages. Sometimes even several languages will be used in proceedings. And once we have established these factors, then we send a short list to the parties. We ask them for their feedback. And then taking this into account, we proceed with the appointment. And then what we also do as a I think quite an important step in between is to make sure that the arbitrator or mediator confirms that he or she has the time and can make the time available to conduct the proceedings efficiently. And then, of course, we undertake a conflict check, which is very important, especially in these international disputes, sometimes with multinational companies involved that have been working with a number of law firms. So sometimes there's a little bit forth and back to make sure that no conflict exists, or if there has been any prior contact, then this would be disclosed so that all the parties are fully aware. And that's a bit the process. We make sure that this happens quickly. It's an important step in a proceeding, but it also needs to take place, and then we can hand over the subject matter to the appointed tribunal or mediator. Thanks, Isha.
Thanks, Heike. And that brings us to the very end of our Q&A session. We will try to answer the remaining questions after the event, so please feel free to write to us. And over to you, Dipankar.
Yeah, thank you, Isha, for doing this moderating this session. And well, ladies and gentlemen, as we conclude our very informative exchange today, I'd like to, on behalf of FICCI, ICA, and WIPO Center, thank all the distinguished speakers, Ms. Wolgast, Ms. Luthra, Ms. Claire, Mr. Thakur, and Isha. Of course, I've been interacting with her for a very long time for this very informative for their very informative presentations and also their interaction with the participants today. On behalf of FICCI and ICA, I also extend our sincere thanks to WIPO Center for partnering with us in organizing this important event. And of course, big thanks to all the participants for joining us today and for your attention and interaction. We certainly hope you found the discussions useful and informative. Once again, thank you all and a very good evening. Thank you. Thanks so much.
Thank you, Dipankar. Thank you.
Thank you very much. Thank you.
Thank you.